Good afternoon. This is Ron Williford, and we're here to talk. Let's talk money. Today, our topic is going to be estate planning, and my guest today is someone that I've known actually my entire life. Actually, my brother Don Williford is here. He's an attorney, and he's here to answer some stuff on estate planning to make it as easy as possible. Welcome, Don.
Oh, welcome to you, and thank you for having me.
Tell us a little bit about yourself and what your practice involves.
Well, I don't know if it's obvious, but I am your identical twin brother.
Yes.
I'm a lawyer. I practice in the Delaware Valley area, and one of the areas of my practice is estate planning, estate administration, and so forth.
Okay, so this estate planning process, what does it involve? Is it complex or is it something simple? What do people need to look when they think about estate planning?
Well, it can be complex, but it can be made simple.
Okay.
With estate planning, what you're looking to do, obviously, number one is avoid probate. And what probate is, it's actually taking a will, following it in Pennsylvania with the Register of Wills, and going through a whole estate administration process. That process can be lengthy and it can be complicated depending on the issues involved in the estate. So you want to avoid that. There are ways of avoiding that. In Pennsylvania, we have an inheritance tax.
Okay.
And you want to put together things so that you avoid an inheritance tax. And depending on who's inheriting certain property, there's certain levels of taxation to children of the decedent, 4.5%, siblings, 12.5%, and anybody else, 15%. So those are the two primary goals, and they could be simple goals, and there are some simple ways to achieve those goals.
Okay, now going back, what's the real definition of a will? Can I just write on a piece of paper what I want to do, or do I need some official document to be able to constitute a will, or my last, as they say, will and testament?
Well, you don't need a fancy document. In Pennsylvania, your writing has to indicate some type of testamentary intent. In other words, when I die, this is who I want to have my property,
okay,
and so forth. And you have to have two witnesses. And you necessarily don't need a notary, but it's best to have a notary notarize not only your signature, but the two witnesses' signatures.
Okay.
And that way it's called self-authenticating. When a person dies, you can just walk into the Register of Wills. As long as it looks okay, then it can be probated.
Now, my loved one has passed away or died, and let's say I go to the Register of Wills and I don't have a will. What do I need to do? Is there anything I need to do?
Well, there's levels of who can open an estate. If you're married, you said your wife?
I said my loved one.
Loved one.
Let's assume it's my spouse. Yes,
your spouse. Okay, if it's your spouse, you as a husband, you have priority over the estate. So all you would need is a death certificate and your identification.
Okay.
And then give the Register of Will some indication of the size of the estate.
Okay.
And then they would open an estate, and that would be it to open the estate. But of course, there's more that goes on.
Okay, so I've gone to the Register of Wills, set up the estate. What would be the next step? Because I think a lot of folks, the loved one is deceased. They don't know which direction to go. I run into situations where no one's open probate. They've done nothing for years, and then it circles back when they want to decide to do something. It's, you have a deed that's tangled, you have properties and things that just aren't registered, and you can't do nothing. You're stuck. So what's that next step?
Well, trust me, I've had many of those situations come into my office. Well, after you open the estate, the next thing you want to do is put advertisements in the newspaper. And what those advertisements do is they give notice to the world that an estate has been opened.
Okay.
And if there are any debtors, they're to present their, debts. And if there are any creditors, they're to present whatever their claims are. And then within 30 days, you've got to send out within 30 days, notice of beneficial interest to those who may be entitled to a share of the estate. Then there's a streamline of other deadlines that you have to meet until ultimately, within 9 months of the date of death, you had to file the inheritance tax.
Okay.
You don't have to pay, but you should, or you have to file. If you don't file within that time period, then you can be assessed penalties and interest.
Okay, it's kind of like paying income tax.
Yes.
Okay, so
The equivalent.
so basically you got 9 months to get everything in order before you do the inheritance tax.
Now understand that inheritance tax isn't an income tax. Some people get confused
Okay,
by that.
right. What about properties? Is there a way to title properties so that you can avoid probate, or
Right.
you can't do that?
You mentioned should your spouse die. Well, if you own your property jointly, that property would avoid probate and go to you automatically by operation of law. And that's with any other property. If property's held as joint tenants with the right of survivorship, that property passes probate and goes directly to that individual. There still could be a tax, but
Okay.
that property passes automatically, so you don't have to go to the Register of Wills, get sufficient legal paperwork in order to transfer the property.
Now, are there different ways you can title stuff? I know there's joint tenants with rights, what is it, entirety, where...
Well, that's marriage.
Okay.
But for anyone else, it's joint tenants with the right of survivorship.
And it has to be spelled out specifically?
Specifically on the deed. If not, then the property could be held as tenants in common. And should one tenant die, that 50% would go to his or her heirs. And I have that situation.
Okay, now the will, are there any other documents, legal documents beyond the will that people should be thinking about when they're looking at estate?
I mean, if you want to get more sophisticated, you can do what's called a living trust.
Okay.
And what that is, you would put all of your property into trust today. It's in trust, but you can still use it for your benefit.
Okay.
And then upon your death, that property would pass outside of probate.
Okay.
But you'd still have to pay a tax, but it's going to pass outside of probate.
So you basically can't avoid the inheritance tax?
Not at all.
Now,
But,
is there a federal inheritance, or is it just
well,
state?
federal, if your property is approximately $5 million or above, there could be an estate tax, and it's not inheritance, and state is upon the estate itself.
Oh, okay, so it's...
It doesn't, no
estate-
matter who gets it, it's an estate tax.
Okay, so in the state of Pennsylvania, it's inheritance tax.
Correct.
For the federal level, it's called an estate tax.
Correct.
Okay, yeah, so
And
there
you'd
is a
have to
distinction.
right, you'd have to have a large estate in order to be hit with the estate tax.
Now, what are the rates for the estate tax? If this so happens I might be wealthy and I have over that $5 million.
I wouldn't know it offhand, to be honest with you.
Okay, are there any tables or...
Yeah, there are tables, and of course, if someone that wealthy came in, I would have that knowledge or get that knowledge.
Now, the other thing is, recently Aretha Franklin, she passed away late last year, like the fall, and initially she didn't have a will, and was going through the court systems, and then I just recently saw that someone found a piece of paper in her property. Now, how would that change the process? She didn't have a will before, but now something shows up. What happens in the process of probating that will?
Well, let me first say, excuse me, I'm a Pennsylvania lawyer. I don't know what they do in Michigan, but if Aretha Franklin were living in Philadelphia,
Okay.
despite what she may have written, she still would have to have two witnesses
Okay.
to whatever she wrote. And I've had that situation too. Someone wrote a letter of how they wanted their property devised, and the person responsible honored that person's wishes, but otherwise it probably wouldn't have been a valid
Now, when
will.
you say witness, is it a witness that simply signed the document, or do those witnesses have to appear somewhere?
If you're going to sign as a witness, first you have to be competent,
Okay.
and over 18, but anytime you witness anything, key word is witness, at some point you may have to testify in court. So if you're not looking to testify in court at some point in time, then you may not want to
Now,
witness.
what if the witnesses can't be found, or they're deceased?
I would say in that point, I mean, it's going to be hard to prove that that was Aretha's will,
Okay.
or that, that was her testamentary intent.
Okay, great. Now, she only had, I think, 4 sons. So would they get equal share if they were in Pennsylvania? Or would the courts determine the distribution?
That's well, she didn't have a spouse. The sons would get equal shares.
Okay. Now, one thing that you had mentioned, a living trust, and you put your money in trust. What's the major difference between having a will and then setting up a trust? Are there any differences?
Well,
should everybody be doing a will, or should everybody be doing a trust?
Well, the will you have to file with the Register of Wills or probate.
Okay.
With the living trust, which says essentially the same thing as a will, you don't have to probate, and that would be the advantage of a living trust. But in order to do a living trust, you must make sure that your property is placed in the trust.
Okay.
Certain assets you can't place in the trust, like a house that you own jointly with your house. Obviously, today you can't put that in trust.
Okay, right.
So
now, when you go, let's say you have a trust, is it the same process to go to the Register of Wills with the trust, or how do you figure that out?
Well, the trust you don't have to probate; it's not made public.
How would the state know you inherited this money?
They wouldn't, but
okay.
It would be your obligation to pay an inheritance tax on whatever that property is, and in most cases, the state will find out about the property.
Okay. Now,
through bank accounts and so forth.
So basically, if you set up your accounts the proper way, there's no pressure to really have a will, or should you have?
Well, when you do that, you have the living trust, which takes stuff out of probate, but you still want to have a will, and it's called a pour-over will, and it's exactly as it sounds. You don't mention anything in the will. Okay. Except that it's going to, and you don't use the words pour over, but you say that it's going to pour over into your trust. You're telling the person to look at the trust, and that's how I want my property distributed.
Okay, so simple, does simple just means the simple language, or is there a simple will or different variations in wills? Or?
Well, a simple will is simple.
Okay.
It could be complicated.
Fair enough.
You could do a will with trust. You can do a will in so many ways.
Okay, now I know from my experience, life insurance isn't taxable, but is that included in your inheritance tax?
No.
Life insurance.
There's certain assets that pass outside of probate. Okay. Insurance being one. Most instruments that have a beneficiary named, they pass outside of probate.
Now, what about for 401k, you got to name a beneficiary.
Right.
Does that bypass, or does it have to be included as?
It's not a part of the estate.
Oh, really?
But it could be subject to another tax.
What tax is that?
Income.
Okay, right. Yeah. Income tax. I always thought that if you
No, I'm not an accountant. So
okay.
We're going to talk about that.
I thought that if you inherited a 401k, that it had to be a part of that estate, but
anything that has a named beneficiary passes outside of the estate and is considered a non-probatable asset.
Okay, now are there ways to set up like a bank account with what is payable upon death? I forget the
POD, payable upon death. It's a simple trust or a Totten trust. You just go to the bank and say, look, I want this account payable on death. And they'll designate the account as such. But it's still subject to tax.
But it will be payable to that individual.
Right.
They wouldn't have to go and do anything else. It would just be payable to them, but there would be inheritance tax.
Right. They'd have to at least file an inheritance tax return with the Register of Wills.
Okay, now with your regular income tax, you got different forms that you do. You have an easy form, which, if it's simple, is the inheritance tax that simple, or is it pretty complex?
I mean, it's relative. I mean, you have your gross estate, and you're entitled to certain deductions.
Okay.
And what I'm doing, I try to bring down that gross estate as much as I can, and the tax, depending on the percentage, is on the net balance. You can deduct funeral expenses.
Okay.
You get an exemption if you were a relative living with the person. You can deduct my fee, administrative fees, court fees, cost of administration.
Now, as let's say the executor or executrix, are there any fees that you can pull?
Yeah, you can take a fee as an administrator or executor, and I usually recommend that the person do that, but
Okay.
that's subject to income tax.
Okay. Now, we had mentioned probate. Let's say an estate hasn't been probated and it's 15, 20 years later. Can you now circle back and do the probate, or is it, or with that after that 9 months, that's it?
No, you can walk right into the register of wills anytime up to the 21st year after the person's death.
Oh, so it's 21.
Right.
Okay.
After 21 years, technically, you would have to file a petition to allow you to start probate.
Okay.
But some register of wills, regardless of the time period, allow you to walk in.
Okay, so let's say you didn't probate it and it's just and not a probated estate. Can someone else come in and do anything with that?
Well, you have to
Estate?
present proper identification, of
Okay.
course. You just can't walk in and say, I'm Sally Mae's son, and they're going to
Okay.
open an estate. You have
Right.
to show some connection. And in Philadelphia, they're even more stringent. In Philadelphia, they want to see your birth certificate,
Okay.
the name of your firstborn, and all of that type of stuff.
Yeah, because I know there are situations where there is a home and then someone else has come in and changed the deeds and the person's deceased, and then the family finds out that, hey, you no longer own the property.
Right.
Does that happen frequently, or?
It must have been happening in Philadelphia. As a matter of fact, I went to record a deed a couple weeks ago, and you walk into Philadelphia and they take your photo, they want your identification,
Okay.
and before they do anything, you've got to wait for the clerk. So it's, from what I understand, rampant in Philadelphia. It does happen.
Now, I mentioned the life insurance part. Now, let's say you had $1 million policy. Does that become a value in the estate, even though?
Passes outside of the estate.
Okay, so anything life
But if it-
insurance.
right, but if it goes over $5 million, it could be subject to the estate tax.
Okay,
tax.
so if you have over $5 million in coverage, let's say life insurance, it could not inheritance tax,
but estate,
but estate tax.
Right.
So there's
Or-
two key words: inheritance tax and estate
estate.
tax.
Now, I don't practice in New Jersey, but I know in New Jersey they have an estate tax
Oh, okay.
based on the value of the
So there's
estate.
actually an estate tax in New Jersey.
Correct, right, correct.
And but is there an inheritance tax?
As far as I know, don't quote me on this. I know there's an estate tax.
Okay, so they just have a straight estate tax.
Right, as far as
So
the-
whatever your estate is, you got to pay taxes on it.
Well, I mean, there are exemptions
Okay.
like anywhere else. I mean,
Right.
spousal type things and children, but I'm not well versed on New Jersey law.
Okay, so if a client comes to your office, what's the typical process for them to begin that process to either do a will or trust? What are the key ingredients? What information should they have when they come to see you?
Well, of course, I want to know who they want to name as the executor or executrix. Today, I call that person a personal representative. I want to know what's going to happen when they die,
Okay.
who's going to get what. And the biggest thing I want to know about their assets and whether or not a will is viable,
Okay.
whether a trust is better, and so forth. And honestly, when you break a person down, especially, married people, you can pretty much put them into what's called a poor man's will.
Okay.
Everything is set up where you're avoiding probate. You're going to avoid tax. Some elderly clients, they make their transfers now, and
Okay.
you're looking, and I say, well, you should at least get a will, but you've taken care of everyone already, so
Okay.
you wouldn't have to probate anyway.
Now, what about if you have children? You're a younger couple. Should you have a will?
Oh, it's definitely,
Okay.
definitely to name who you want to be your guardian.
Okay, so
Of
there's no
course.
magic asset amount that you should start looking
No.
at a will.
No.
Okay, so
Not
if
at
I have a
all.
couple dollars in the bank and I got some kids, and I should start looking at a will
Right.
or some type of protection. I know, God forbid something happens to me.
Correct, and you've got to look at relationships as well. I mean, you're in your second marriage, you have children from your first marriage, your spouse has children from their first marriage, that's going to change things if you don't have a will.
Okay.
Usually in a typical non-will situation, if the spouse and the husband have the same children, spouse would get the first $30,000,
Okay.
and then the children would split the balance. But if any of those children weren't either spouses, then that's going to change things. The spouse would get half, and then the children would get the other half.
Okay, so in most regards, the spouse is going to get $30,000 off the top. This not automatically goes to the spouse.
Yeah, they're going to get, but it depends on
Okay, the
relationships
situation.
and children, you know.
So there's no standard rule or practice. It's basically you just need to go sit down with an attorney and figure out your individual situation.
Correct. However you want your property devised,
Okay.
you got to sit down and spell it out like anything else.
Now, you know, you can probably go to Staples, you can go online, you could develop your own will. How valid are those in the state? Do you recommend people doing that as a safeguard, or should they really do it the proper way?
Well, I'm an attorney, so I'm going to recommend that you get an attorney.
course.
If a person has a toothache, I'm not going to tell them to go to the witch doctor. I'm going to tell them to go to the dentist.
Okay.
And the same thing here. Any legal situation, you need to consult with an attorney.
Okay, so there are, like you said, there's a poor man's will. So to kind of wrap things up, so what you want to do is when you register your accounts, your bank accounts, mutual funds, or whatever, you want to have them set up a certain way.
Correct.
And then the will and trust kind of supersede how you've arranged that setup, how you name your accounts.
Yeah, you want to look at your assets first, and you want to situate them so that they avoid probate. For example, joint accounts, they're going to avoid probate.
Okay.
Insurance is going to avoid probate. Certain financial instruments with beneficiaries, they're going to avoid probate. You want to do that so that you take as many of your assets outside of probate as you can. Joint accounts, that's the easiest way to avoid probate.
Okay, now let's say there isn't a joint account and the spouse has an individual account. Would that create issues or?
Yes, it'd create a major issue. A couple years ago, I had a client. She was faced with a tax sale. Husband kept all the money in his name. He died on a Friday. The tax sale was on a Tuesday. She couldn't get to the money. So what I had to do, I had to file a bankruptcy on her behalf to stop the tax sale.
Okay.
And then she ran open probate, and she was able to get to his assets.
Wow, that sounds pretty complex.
And you can't open an estate until you get a death certificate, and they don't give them to you the day you die.
Now, what if I've had situations with some of my clients where the will is actually in the safe deposit box? How do you probate the will if it's in the safe deposit box?
You got to tell somebody about the safe deposit box.
Can they have access to the safe deposit box? Or?
Once they, well, you can open an estate without the will.
Okay.
And then go in and pronounce to the Register of Wills that there actually was a will.
Okay.
And in fact, you know, with safety deposit boxes, as an attorney or the personal representative, they actually have to go in, inventory that box, and if they find $1 million in there, they've got to report it to the state. I remember years ago, you had to call a state representative.
Wow.
And they would go into the box, and this one particular time I had like
Crooked politics.
yeah, it seemed like 1 million bonds. Oh man, U.S. bonds.
Okay.
We were there forever.
Well, Don, I appreciate you coming on the show today and explaining estate planning, wills, and trust. And you know, we're running just about out of time, but you know, I just appreciate you as my brother and as an attorney. You know, you're my go-to guy, so I want to share your knowledge with my on my show. And Don, we thank you. And as we leave today, I'd like to thank you for listening in. You're listening to Let's Talk Money at Studio 21. Thank you.